Good morning, good afternoon, and good evening, depending on your time zones. A very warm welcome to the 2026 Biennial Global Online Symposium on Human Rights, Sustainable Development, and the Law. My name is Moshita Datta, and I'm currently a doctoral researcher from the McGill Center for Human Rights and Legal Pluralism at McGill University. And today I'll be serving as one of your Masters of Ceremony.
Your Excellencies, honorable judges, distinguished professors, and delegates. We are delighted to welcome all of you, over 3,000 registrants from more than 140 countries, either online with us or watching by video later, to this symposium. I am Dr. Tejas Rao, Senior Manager of the Center for International Sustainable Development Law and a postdoctoral researcher at the University of Cambridge. Together with Maushita, I am pleased to serve as Master of Ceremonies. It is a pleasure to have you here with us. I am also happy to welcome our two moderators for this opening plenary, Advocate Muskan Singh and Advocate Yushi Shen. Advocate Muskan Singh is wearing a white-colored top with glasses and slightly long brown hair, and Advocate Yushi Shen is wearing a green-yellow top with shorter brown hair with a warm smile on both of their faces.
Thank you, Tejas. Hello and welcome to the Human Rights, Sustainable Development and the Law 2026. As Communications Officer of the Center for International Sustainable Development Law, I look forward to serving as one of your moderators for this plenary. It is a pleasure to introduce our chair for the symposium, Professor Marie-Claire Cordonier Segger, who is a world-leading scholar and highly distinguished jurist in the field of sustainable development law and governance. She holds the chair in Sustainable Development Law and Policy at the University of Cambridge, Lucy Cavendish College, and also serving as president of the newly founded Sustainable Development Governance and the Law Association, and chair of the International Law Association's Committee on the UN Sustainable Development Goals. Further, as Senior Director of the Center for International Sustainable Development Law, CISDL, she has published over 29 books and more than 180 papers in 5 languages and advised many governments through the United Nations on sustainable development treaty negotiations and compliance. Professor Cordonier Segger holds PhDs of law from both Oxford and Cambridge and an elected fellow of both the UK's Royal Society of Arts and the Royal Society of Canada, one of Canada's highest academic honors. Last night, she received a Global Sustainability Leadership Award 2026 in the UK House of Lords, and among other honors, she is a laureate of the prestigious H.E. Judge C.G. Weeramantry International Justice Award. Professor Cordonier Segger is wearing a beautiful peacock color coat, has a lovely warm smile, and has beautiful hair as always. Over to you, Yushi.
Thank you, Muskan. Hi, everyone. I'm Yushi. I'm also very delighted to welcome you as a CISDL associate and a doctoral researcher at the Chinese University of Hong Kong. I'm also very delighted to welcome you to this opening plenary to introduce our other chair. Professor Nandini Ramanujan is a full professor and executive director of the Center for Human Rights and Legal Pluralism in McGill University's Faculty of Law. She has also served as president of Board of Directors of the Canadian Human Rights Foundation's Equitas and on the board of Centrate's Greater Montreal and the Welcome Collective of Montreal. Professor Ramanujan holds a PhD from the University of Oxford, is a widely respected expert in international human rights law, legal pluralism, and sustainable development, and serves as a member of the CISDL Board of Governors. Professor Nandini Ramanujan is wearing a white top with short curly hair and warm smile. Professor Marie-Claire Cordonier Segger and Professor Nandini Ramanujan, the floor is yours.
Thank you, and warmest of welcomes to this online biennial global symposium, Human Rights, Sustainable Development and the Law 2026. the fourth in a series that has previously explored the natural world, the Sustainable Development Goals in the Law in 2024, the global economy, Sustainable Development Goals in the Law in 2022, and human rights, the Sustainable Development Goals in the Law in 2020. I understand that thousands of current and future law and policy leaders from over 120 countries have registered to join us at different points during today. Thank you so much for your interest, your engagement, and your commitment. In these times of profound fragility, as conflict, inequality, and a changing climate cause terrible impacts for the most vulnerable, and so many of our commitments made through the United Nations remain unrealized, the case for a rules-based, rights-based international legal order has rarely been more pressing. And yet, legal and governance reform, carefully crafted, delivered through cooperation and compliance, could still help us to foster rather than frustrate our shared aspirations. Across the 17 Sustainable Development Goals and their 169 targets, the urgent need to realize human rights is ubiquitous, a reminder that human dignity and sustainable development are deeply integrated and mutually reinforcing, each lending strength and meaning to the other. As states and stakeholders resolve, despite terrible, turbulent headwinds, to mobilize the courage, creativity, and capacity that we desperately need to implement our international legal obligations on global sustainability, human rights, and indeed, justice, informed dialogue and cooperation matters more than ever. It is in gatherings of this kind, reconciling rigorous scholarship with cutting-edge practice, inspired policy leadership with judicial and legislative integrity, and seasoned wisdom with emerging voices, that new pathways towards a more just, peaceful, and sustainable future together may be found. We have a rich, inspiring, and indeed truly fascinating program ahead. After this opening session, we will turn to a special high-level judges plenary on human rights in the global climate emergency, before moving to experts plenaries 1 and 2, featuring specialist legal voices on new developments in linking human rights and climate change through international law, including fascinating keynotes by CISDL lead counsel Professor Sumudu Atapatu of the Global Network on Human Rights and the Environment, and by Professor Elisa Morguera, the UN Human Rights Special Rapporteur on Climate Change, and on respecting human rights in business, trade, and investment for sustainable natural resources management, with brilliant keynotes by Professor Damilola Olawuyi, my co-chair of the ILA Committee on the SDGs and UNESCO Chair in Environmental Law and Sustainable Development at HBKU in Qatar, and by Professor Thomas Coltier, founder of the World Trade Institute. We shall then enjoy, at noon hour here, 1 p.m. in Montreal, this year's 2026 Honorable Judge C.D. Gonthier Memorial Lectures, graciously provided in this biennial by His Excellency Judge Professor Jire Tladi of the International Court of Justice, alongside special remarks by Her Excellency the Right Honorable Louise Arbour, Canada's new Governor General. We shall also be celebrating the 2026 Weeramantry International Justice Award laureates and the winners of the 2026 Global Fellowship. Finally, we shall return with Experts Plenary 3, focusing on realizing Indigenous rights, intergenerational justice, and rights of nature, with inspiring keynotes by the Honorable Minister Ralph Regenvanu of Vanuatu and Professor Wayne Garnons-Williams of the International Intertribal Trade and Investment Organization and the National 60s Scoop Healing Foundation of Canada, before concluding with a conversation among the plenary chairs to explore emerging trends and future directions. It is truly a remarkable program, and we're incredibly fortunate with the kind and generous speakers who have accepted to join us today. I will now turn to my co-chair, Professor Nandini Ramanujan, to welcome you and contribute her insights.
Good morning, good afternoon, and good evening to colleagues and friends joining from around the world. It is a great pleasure to welcome you to this global online symposium on human rights, sustainable development, and the law, jointly hosted by the Center for Human Rights and Legal Pluralism, together with Sustainable Development Law, Center for International Sustainable Development Law, and I would like to underscore the leadership of Professor Cordonier Segger in bringing this extraordinary symposium together, and the center is grateful to be a partner in this great endeavor. This gathering comes at a critical moment for both the international legal order and the global sustainable development goals agenda. More than a decade after the adoption of the SDGs, important implementation gaps remain. Around the world, communities continue to confront intersecting challenges of poverty, inequality, conflict, displacement, environmental degradation, and climate change. As the symposium description notes, the need to strengthen a rule-based and rights-based international legal order, particularly through the values reflected in SDGs 16 and 17, has become increasingly urgent. At the same time, we are witnessing growing pressures on multilateral cooperation. Fragmentation, geopolitical tensions, and declining trust in international institutions have raised fundamental questions about how we govern shared global challenges. Yet, if recent years have taught us anything, it is that no country can address climate change, forced displacement, sustainable development, or human rights protection alone. The post-war multilateral system has always been imperfect. Nevertheless, it established a framework grounded in cooperation, sovereign equality, and the protection of human dignity. Today, the challenge before us is not simply to defend that framework, but to renew and strengthen it so that it better responds to contemporary realities and serves those who have too often been left behind. Law has a central role to play in this effort. Legal institutions and governance frameworks help translate aspirations into action. They provide mechanisms for accountability, channels for cooperation, and safeguards against arbitrary exercise of power. They can also create the conditions necessary for sustainable development by supporting climate action, responsible business conduct, equitable economic participation, indigenous rights, protection of indigenous rights, intergenerational justice, and the protection of human rights in general. These themes are reflected in the rich program of discussion that will unfold throughout today's symposium. Importantly, the pursuit of sustainable development is not solely a technical exercise. It is fundamentally a question of justice. It asks how we distribute opportunities and burdens, how we protect vulnerable communities, and how we ensure that future generations inherit institutions and environments capable of sustaining human flourishing. This symposium brings together leaders, scholars, practitioners, judges, policymakers, and emerging researchers from diverse regions and disciplines. Such dialogue is more important than ever. In a world characterized by complexity and uncertainty, thoughtful engagement across perspectives can help generate the innovative legal and policy solutions needed to advance the Sustainable Development Goals agenda and strengthen respect for human rights. I hope that today's conversations will not only deepen our understanding of these challenges, but also inspire practical collaborations and renewed commitment to the principles of justice, sustainability, and international cooperation. Thank you for being with us today. I wish you and all of us a stimulating and fruitful symposium.
Thank you so much, Professor Nandini. It is an honor and a pleasure to be sharing this symposium with you. And indeed, it is also a very great pleasure to be able to introduce several distinguished speakers to offer their welcomes opening our event. I will be brief in introducing them because each of them is playing an incredibly important role later on during the day as chairs or keynotes in various different sessions. We are joined now on the panel by Dr. Ashfaq Khalfan, Director of Climate Justice in the Global School of Sustainability in the London School of Economics, former legal director of Amnesty International, and chair of the CISDL Board of Governors. He has a bit of a beard, not too much, and charmingly ruffled dark brown hair, and he is looking quite relaxed and happy in a button-down shirt of the pale sort of blue. I'm also very, very happy to be joined by the Honorable Elizabeth Maruma Mrema, Assistant Secretary General of the United Nations and Deputy Executive Director of the United Nations Environment Programme. She is a laureate of the Weeramantry International Justice Award, and a fulsome introduction to her will be given later, but it is truly a pleasure to see her online and to be able to collaborate with her in this context each biennial. She has beautiful brown hair, glances, light rose-tinted lips with a giant smile, and a beautiful colored coral shirt. Professor Damilola Olawuyi is also here online with you, UNESCO Chair in Environmental Law and Sustainable Development at Hamad bin Khalifa University, and a Vice Chair of the International Law Association. He is also a laureate of the Weeramantry International Justice Award and Deputy Vice Chancellor of a marvelous university in Nigeria. So we're incredibly honored that he's been able to make the time to join us for today. He is smiling at us with dark-rimmed glasses, very short dark hair, an extremely charming suit jacket and light blue shirt, and some beautiful books in the background. And finally, Professor Wayne Garnons-Williams is the founding president of the International Intertribal Trade and Investment Organization and CEO of the National 60 Scoop Healing Foundation of Canada. He is online with us, looking very serious and distinguished, and he's just waved and smiled with nearly rimless glasses, an extremely distinguished coat, and a blue shirt. He is together with Professor Damilola, the Honorable Elizabeth Mrema, and Dr. Khalfan here to welcome us and open this symposium. Dr. Ashfaq Khalfan, if we can turn to you first.
Thank you, Mary-Claire. Thank you, everybody. Hello, everyone. It's a privilege to welcome you on behalf of the Center for International Sustainable Development Law, where I'm the chair of the board, to this biennial symposium. CISDL was established in 2002 and is now in its third decade of work advancing international law and governance for sustainable development. And it's a real pleasure to see that mission reflected in the wide range of registrants joining us today. I believe we have over 3,000 registrations, and I can see we have 300 people right now, and of course, many will be joining later. So one thing that makes the symposium distinctive is the wide range of people. We have judges, UN special rapporteurs, experts, practitioners, and scholars from all the generations and younger generations from over 100 countries. So I want to say a little about the thinking that underpins the program today. Human rights and sustainable development are often, not by many, but not by everyone, but by some or by many, certainly in the established discourse, are framed as separate things. You have separate centers covering different areas, and that is a missed opportunity. In fact, one of the founding thoughts and ideas behind the center was to go in the other direction. It's been useful and important to see that over the last 2 decades, international courts, human rights treaty bodies, environmental bodies, increasingly grappling with the links between those two areas. We'll hear from the judges directly in the next few panels. I also wanted to mention the UN Committee on Economic, Social, and Cultural Rights, which adopted the General Comment on Sustainable Development, which that was adopted just last year and very comprehensively addressed the links between the areas of law. Unfortunately, the rapporteur for that general comment is in Colombia right now at another conference and couldn't join us, even though she wanted to. So in terms of the links between human rights and sustainability, you'll see that running through CISDL's programs from climate, health, trade investment, natural resources, and other areas. All of these integrate the role of human rights and its implications. And that's the thread that draws the symposium together. Now, none of this would be possible without our partners and the people. So I want to say thank you to our co-hosting partners at McGill University, where our chairs are physically sitting right now. The chairs of the symposium. The University of Cambridge, the LSE, where I'm based, and the institutions across the globe. Many of them, you'll see them listed on the program, who have shaped today's program, either all of it or particular sessions. And I really want to express some gratitude to the many volunteers, researchers, and young professionals whose work behind the scenes makes, and ahead of the event, makes an event of this scale and quality possible. So I really want to thank their commitment. And for those of you who are here as participants, I want to encourage you to engage actively. The symposium has been set up so that you can ask questions, bringing your own perspectives in the Zoom Q&A. Please don't forget to introduce your name, your country, your institution, if you like, just so we have a sense of who you are and to engage with you in a real dialogue. And of course, I hope we'll all carry these conversations forward once the symposium ends into your institutions, your research, your advocacy, and your communities. And with that, I'd like to hand over to the next colleagues, and I look forward to the discussions to come. Thank you.
Thank you. And Honorable Elizabeth Mrema.
Thank you very much, Claire. Let me take also this opportunity, like others, to welcome all participants on behalf of the United Nations Environment Programme and really express our delight at an opportunity not just to co-chair this session and support this symposium, but also to be able to exchange views and share perspectives. As we all know, we are in a world or era of geopolitics, which have put to question the importance of international cooperation and multilateralism. And yet, today, multilateralism has become even more important than ever before. And I'm saying so because as lawyers, we see still governments agreeing to sit down and negotiate new agreements, negotiate new commitments. So clearly, multilateralism is still working, and the role of lawyers and judges then become even more important because you will be the ones to make sense of all these new instruments currently being negotiated. For instance, we have the plastic pollution on marine environment being negotiated. We just had the marine biodiversity beyond national jurisdiction entering into force earlier this year, and countries are in the process of implementation. And this is where the role of lawyers to support countries at national level also comes in. So at this juncture, and clearly when we are seeing the Sustainable Development Goals are at the midpoint review, and this midpoint review has revealed, unfortunately, still significant gaps. And as we in this symposium, delegates, ministers are in New York at this moment, looking and reviewing the status of the implementation of the SDGs. So, but then this is what is coming out clear. Implementation gaps still exist. The triple planetary crisis of climate change, biodiversity loss, and pollution continues to accelerate. And this is where then UN Environment Programme's work becomes important, as has been demonstrated over time, over and over again, that human rights and environmental protection are indispensable, are connected, and therefore the health environment is a precondition for the enjoyment of all the rights, including human rights. Let's look at the importance of law and governance as a connectivity issue between ambitious global commitments and the real-world outcomes for people and the planet. But I'm confident with our today's dialogue, which brings together the finest legal minds across the region and disciplines. And not surprising that we have over 400, going to 500 participants engaged with us. Clearly, these issues we are discussing today are important and key to all of you. And this, hopefully, by the end of this symposium, will be able to yield the insights, to yield the partnerships needed to accelerate progress. So let's bring those minds together as we exchange ideas during this symposium. Thank you very much.
Warmest thanks to you. I will now turn to Professor Damilola Olawuyi.
Thank you very much. And it's my great pleasure as Vice Chair of the International Law Association to welcome you all to what promises to be a wonderful and refreshing 2026 Global Online Symposium on the theme Human Rights, Sustainable Development, and the Law. With just 4 years to the 2030 target of the UN Sustainable Development Goals, the SDGs, it is now obvious that time-bound targets alone will not deliver transformation and sustainable development in our societies. Pollution, climate change, biodiversity loss, the rapid degradation of forests, heightened contamination of our environment, the theft of cultural and natural resources due to conflict and wars remain pervasive problems. Also, business irresponsibility in key sectors, including in agriculture, mining, oil and gas, water, and so on, is driving modern slavery, child labor, and gross inequalities across the world. Evidently, the SDGs and whatever comes after it might remain elusive without a shift in mindset from a compliance and tick-the-box approach to a responsibility and accountability approach that moves beyond not just doing no harm, to doing good as well. This is why the International Law Association is institutionally committed to leveraging the instrumentality of international law to advancing environmental stewardship. Since 1873, when the ILA was established in Brussels, environmental protection and sustainable resource governance has remained central aspects of our focus and mandate. And I'm very proud to co-chair the ILA Committee on International Law for the SDGs under the able leadership of Professor Marie-Claire Cordonier Segger. This committee, as well as other initiatives, have evolved in different forms for many decades in the ILA. So we welcome you to engage with us and with other initiatives of the ILA. Let us remember that whatever we do today will become history tomorrow. We therefore hope that you will take the opportunity of this conference to renew our commitment to human rights, accountability, and stewardship for the use of the environment and its resources within its carrying capacity. On behalf of all of us in the ILA, I welcome you all to today's event and wish us all a rewarding and successful deliberation. Thank you.
Warmest of thanks to you. And I would ask that all speakers in the opening, please keep your cameras on. We are taking a few screenshots for you with your beautiful smiles. I'm going to turn now to Professor Wayne Garnons-Williams.
Hello, Danse. Great to be here. Just a little bit, if I can, just a tiny time. I'm a litigator by trade, and I've been taught in the rule of the 3 Bs in making a presentation. The 3 Bs are be up, be brief, be gone. So I'm going to be very quick about this, but you don't know who I am mostly, and you haven't heard my organizations. You don't know what it's all about. So I just need to give you a quick little briefing. I'm Chief Executive Officer of the National 60 Scoop Healing Foundation of Canada. Now, we represent 30,000 survivors of the 60 Scoop, and that's Inuit, First Nation, and status and non-status Indigenous people across Canada. So what, you ask, is the 60 Scoop? Well, it's a weird phrase, and it's out of sorts, but it's basically between 1951 and 1991. It's the illegal theft by the government of Indigenous babies and children from their families and communities, and the placement of these precious Indigenous innocent children in non-Indigenous adoptive homes and foster care and welfare institutions without parental consent or any hope of connection to their Indigenous family, their Indigenous origins, the community, language, or culture. So I'm the CEO of that, among many hats, but I'm happy to just give a little brag point for this is the fact that our foundation has managed to grant, since its inception, $15 million to 89 organizations across Canada, to Inuit, Métis, and First Nation organizations to help survivors begin the act of reconciliation, returning to their communities, returning to their culture and language. The other organization that you probably don't know about as well is I also represent IITIO, the International Intertribal Trade and Investment Organization. We've been around for 12 years, and we've got representatives from the United States, Canada, New Zealand, Australia, Ecuador, Taiwan, Peru, Mexico, and more join all the time. And basically what we're trying to do is elevate the discussion for international Indigenous trade and how we can exercise those rights in a way that is recognized for the nation state and for the Indigenous peoples. And we've got a bit of a brag sheet. We've done a lot of good stuff. We've helped develop Canada's first Indigenous trade policy to the world, which helped develop with the United States, Mexico, Canada, agreement with respect to the Indigenous provisions. We've also been negotiating for the Canadian and New Zealand group, the IPECTA, which you'll probably hear more about the 2 o'clock thing, which is the Indigenous Peoples Economic Trade and Cooperation Arrangement, which is really cool. And we've done Mercosur and the Canada-Ecuador trade agreement, having Indigenous trade chapters there. So we've done a lot. And I'm happy to welcome you here. And I'm giving a plug for our 2 p.m. Eastern Standard Time discussion on realizing Indigenous rights, intergenerational justice, rights in nature. So we'll be talking more about the Sustainable Development Goals 14, 15, and 16. And just to give a tip a little bit about this, there's an awful lot that is a crossover concerning the United Nations Declaration of the Rights of Indigenous Peoples and the Sustainable Development Goals. So with that, I will say thank you and welcome.
Thank you so much, Professor Wayne, Professor Damilola, Honorable Elizabeth, and especially Dr. Ashfaq. It is marvelous to have you with us to open this symposium. Finally, it is an honor and a pleasure to welcome opening remarks from the United Nations Deputy High Commissioner for Human Rights, the Honorable Awa Dabo, before we move directly into our first high-level session. Awa Dabo is a human rights lawyer with extensive experience in crisis recovery, peace building, transitional justice, humanitarian affairs, and development, having served as deputy and head of the UN's Peace Building and Peace Support Office, and then as director in New York, and as chief of country oversight and support for the UNDP's Regional Bureau for Africa, among other extremely significant international roles. With this, I invite our Masters of Ceremonies, Dr. Tejas Rao and Advocate Mushita Dutta, to play the brief video greetings that her excellent office has kindly provided to help open our symposium.
Excellencies, distinguished guests, colleagues and friends, it is a pleasure to address this International Symposium on Human Rights, Sustainable Development and the Law. I thank the Center for International Sustainable Development Law, the McGill Center for Human Rights and Legal Pluralism, and all partners for convening this important conversation at a moment when our collective choices matter profoundly. The climate emergency is not only an environmental crisis, it is a human rights crisis. Floods, storms, droughts, wildfires, sea level rise, and shifting weather patterns are already affecting rights to life, health, food, water, housing, culture, development, and a clean, healthy, and sustainable environment, among others. Those who contributed least to greenhouse gas emissions often bear the heaviest burden. Climate change deepens inequalities, undermines progress towards sustainable development goals, and leaves far too many behind. That is why climate action must be grounded in human rights. Human rights law and mechanisms provide a practical framework for participation, transparency, accountability, non-discrimination, and access to remedy, while guiding states and businesses in their obligations and responsibilities in the context of climate change. Human rights reminds us that to be effective, Climate policies must be fair, ambitious, and inclusive. This is especially important for climate finance. Funding for mitigation, adaptation, loss and damage, and a just transition must reach those most affected, reduce inequalities, support participation, and strengthen accountability. A forthcoming Secretary General's report will further address these issues. As the world accelerates the energy transition, we must ensure it is truly just. Critical minerals are essential for renewable technologies, but their extraction and processing can carry serious human rights and environmental risks. Businesses in these value chains have a responsibility to respect human rights. A just transition must respect affected communities, land and cultural rights, protect environmental human rights defenders, ensure access to information and remedy, and guarantee fair benefit sharing. The law is also evolving. Courts and human rights mechanisms increasingly affirm that inadequate climate action can violate human rights obligations. In 2024, the European Court of Human Rights in Klima Senior Renan versus Switzerland found that inadequate climate action could breach human rights obligations. In 2025, the Inter-American Court of Human Rights clarified states' duties in the climate emergency, while the International Court of Justice affirmed duties to prevent significant environmental harm, protect the climate system under human rights law, and provide reparations where violations occur. The ICJ also affirmed that a clean, healthy, and sustainable environment underpins other rights, and that failure to act on GHG emissions, including fossil fuel production and subsidies, may constitute an internationally wrongful act. Another request for an advisory opinion on climate change is currently pending before the African Charter on the African Court on Human and People's Rights. These recent legal developments clarify obligations, strengthen accountability, and affirm the centrality of human rights in climate action. They send a clear message. Protecting the climate system and protecting human rights are inseparable. Environmental law, human rights law, and sustainable development are mutually reinforcing. Together, they offer a path towards climate justice and a human rights economy that protects the planet and places dignity, equality, and sustainability at the center of decision-making. As we approach key Sustainable Development Goals milestones and a look beyond 2030, human rights must remain at the heart of the global development framework. Today's choices will shape the rights, opportunities, and security of future generations. Young people are calling on us to act now, fairly, and urgently, and in this spirit, I highlight the Global Alliance for Human Rights, launch to mobilize governments, civil societies, cities, academia, youth, and communities around a shared commitment to human rights ahead of the 80th anniversary of the Universal Declaration of Human Rights in 2028. I encourage all stakeholders to support the Sumauma Pledging Tree for Human Rights-Based Climate Action, a global alliance initiative for ambitious, inclusive, accountable climate action grounded in human rights, learning, and exchange. Let us approach the climate emergency not only as a threat, but as an opportunity to build more equitable societies, strengthen participation, protect nature, and advance human rights for all. I am confident that today's discussions will help advance that shared effort. Thank you.
I'll take this moment to thank all our partners for their inspiring greetings. This concludes our grand opening, and I'd like to extend my warmest thanks to our hosts, welcome speakers, and especially to my co-chair, the extraordinary Professor Marie-Claire Cordonier Segger, with whom it really is a privilege and pleasure to serve as a co-chair. We are now pleased to proceed directly to open our first high-level plenary with leading judges of the European, Inter-American, and African Courts of Human Rights on the critical issue of human rights and the global climate emergency. Thank you.
Thank you, Professor Nandini, and it is a pleasure to be with you. I'm going to say thank you as well to all of our opening speakers, partners without whom it would be impossible to organize a symposium of this relevance and magnitude. It was a pleasure to share the opening with you. And it is also, of course, a great honor to directly welcome our highly distinguished judges and international human rights law experts for this new high-level judges plenary. We will all stay on the same link, and we'll simply welcome our three speakers directly now. In recent years, the European, Inter-American, and African human rights and people's rights courts have each been asked to carefully consider and provide landmark rulings and advisory opinions connecting human rights obligations to climate change in the world today. Today, we are privileged to hear directly from distinguished judges of each of these three leading international courts. Please note, our expert speakers have kindly agreed to keep their initial remarks fairly brief in order to hopefully have an opportunity to take a few comments and possibly even a round or two of questions from our online audience. And I note that we have over 500 people from around the world online with us just now, and I know that there will be more throughout the day and even more over video. So please do enter your comments or even questions into the Q&A, especially noting your name and your country so that our online moderators can share your name and country as well as your question with the plenary if the opportunity arises. I'll now turn to my co-chair.
To unmute. This has not been great. Okay. Once again, I was on mute. I would like to extend warm greetings to Honorable Judge Anya Sieber-4, who is the judge of European Court of Human Rights. She has previously held a chair in international human rights protection at the University of Göttingen and has been a leading scholar and practitioner at the intersection of human rights and environmental law. She was among the European Court of Human Rights judges involved in the landmark 2024 climate judgment. Our next speaker would be Honorable Judge Patricia Perez-Goldberg, who is a judge at the Inter-American Court of Human Rights, serving with distinction and contributing to the court's growing jurisprudence on environment and climate rights in the Americas. Honorable Judge Duncan Gaswaga is a judge of African Court of Human and People's Rights, bringing to the bench a distinguished career in public international law and human rights advocacy across the African continent. We now invite each of our judges to make their brief remarks to begin with.
And I'll just jump in with physical descriptions for the sight impaired who are with us today. Judge Anya has a short, beautifully curled bob cut of blonde hair and a big smile, distinguished looking glasses, pearls and a black blouse. Judge Patricia has also dark rimmed glasses, but beautiful, luscious black hair and a large smile with a scarf and a black suit coat and a white blouse. And Judge Gaswaga is looking extremely distinguished in a room with dark gray curtains in the back with a red tie and a black suit jacket and rimless glasses, and he has just waved to all of you. So we will turn first to Judge Anya Siebert-4. Thank you again.
Thank you very much, Professor Ramanujan, and also to Professor Cordonier Segger. It's a great privilege and a very interesting introduction, which is very kind. And thank you very much for giving me the opportunity to share with you some thoughts on the relevance of human rights law for climate protection. Ladies and gentlemen, it is a great honor to speak to you on this occasion about the contribution that my court, the European Court of Human Rights, has made in this respect. Although there is no specific right to a healthy environment in the European Convention on Human Rights, it is increasingly being seized by individuals and non-governmental organizations to help make progress on a wide range of environmental issues, including climate change. Now, before the court had to deal with this very specific issue concerning climate change, it had already ruled on some 300 environmental related cases since the 1990s. So we have gathered some kind of experience in this respect, and we have applied various rights such as the right to life, but also the right to private and family life. With regard to a broad range of issues, including different kinds of pollution and environmental disasters. While these cases, however, were usually related to environmental harm suffered by individuals and caused by a local source, the issue of climate change as a global phenomenon raises new and very complex issues. The court, my court, the European Court of Human Rights in Strasbourg, had the opportunity to deal with those in the case, which was already mentioned by the previous speaker, Verein Klimasenioren Schweiz versus Switzerland. In this case, a Swiss association of elderly women who were concerned about the consequences of global warming on their health, as well as 4 individual Swiss women, complained that the domestic authorities were not taking sufficient action to mitigate the effects of climate change. The major issue that the court was confronted with in this first climate change case was the question to what extent individual human rights could be relied on to protect a matter which is in the interest of everyone and thus could be claimed by virtually anyone in the world. Remember that the Paris Agreement describes climate change as a common concern of mankind. This raised several substantive and also procedural issues. Up to then, it had been unclear which rights protected under the convention could be resorted to in order to oblige states to take climate action. It was therefore groundbreaking when the court recognized in its judgment of 9th April 2024 that the convention encompasses a right of individuals to effective protection by state authorities from the serious adverse effects of climate change on their lives, health, well-being, and quality of life. In this context, the court has introduced intergenerational burden sharing as a new concept. It recognized that future generations are likely to bear an increasingly severe burden resulting from present failures to combat climate change. It is because of the irreversible adverse effects on the enjoyment of essential human rights by future generations that governments are legally bound by the convention to take action already now. To be more concrete, states are required, and this was outlined in this very long judgment, that states are required to specify a target timeline for achieving carbon neutrality and to set out reduction targets for this purpose. These targets need to be implemented, complied with, and regularly updated. Furthermore, these mitigation measures must be supplemented by adaptation measures aimed at alleviating the most severe imminent consequences of climate change. And finally, there are some procedural safeguards which need to be developed in order to ensure that the public is fully aware of the consequences and of the measures taken, and that they can participate in the decision-making process. So in the case of Switzerland, the court found a violation of the convention because the respondent state had not acted in time and in an appropriate manner to devise and implement the relevant legislation and thus had failed to comply with its protective obligations. Now, before I conclude, let me turn to the question how climate-related rights can be enforced judicially. While the primary responsibility lays with the governments, which need to take legislative action, this needs to be complemented by judicial oversight. The remit of domestic courts and of the European Court of Human Rights is thus complementary to those political processes. For this purpose, there needs to be access to court in order to challenge shortcomings in the implementation of climate change as a means through which the convention rights of those affected can be defended. In the case of Switzerland, it found a violation of the right of access to justice because neither the individuals nor the association had been able to challenge the effective implementation of existing law before the domestic courts. In fact, the action by the individual applicants before the Superior Swiss Court had been dismissed as they were not deemed sufficiently and directly affected by the alleged failings. Moreover, the court has recognized that associations can eventually turn to the European Court of Human Rights as an international court to represent the individuals whose rights are or will allegedly be affected. So to sum up, the court's judgment in the Swiss case stands for an authoritative judicial recognition that anthropogenic climate change poses a serious threat to the enjoyment of human rights. By recognizing an individual right to effective protection from the serious adverse effects of climate change, this right has become a legal benchmark for any government action in Europe. The court's climate change jurisprudence thus adds an additional layer to the multi-level and polycentric system of climate protection, including the Paris Agreement. This applies to all 46 states parties to the European Convention of Human Rights. However, instead of putting itself at the place of a democratic decision-making process, the court activates political processes and ensures that the implementation of climate legislation is subject to judicial oversight. This brings me now to the end of my short presentation, and I thank you for your attention and look forward to any questions that you may have. Thank you.
Warmest of thanks, and we turn now to the Honorable Judge Patricia Perez-Goldberg.
Well, thank you so much. Good morning, good afternoon, and good evening, distinguished colleagues and friends from all over the world. Thank you so much for this opportunity to share with you some remarks about the differentiated impact of climate emergency on children and adolescents, indigenous peoples, and future generations as developed in the Inter-American Court Advisory Opinion OC 32/25. But first, I would like to begin with three paradoxes that frame why a differentiated approach matters at all. This opinion, our opinion, is very long, but I would like to focus in this specific issue about differentiated impact. But first of all, as I said, I would like to reflect a bit about these paradoxes. I think we meet a moment that's thick with paradox. As we speak, Western and Southern Europe are emerging from what the World Meteorological Organization has described as an exceptional sequence of heat waves this year, during which France recorded its hottest days since national records began in 1947. And thousands of deaths linked to extreme heat have been recorded across the region. At the same time, the world is in the midst of the FIFA World Cup, underway since June 11 and now reaching its knockout rounds. An event that has brought enormous collective joy to hundreds of millions of people, and that independent assessment, since FIFA itself has published no terminal-wide figure, estimate will generate between roughly 7.8 and 9 million tons of CO2 equivalent by its close, making it the most carbon-intensive World Cup in history, driven overwhelmingly by long-haul spectator air travel. And the very technologies we increasingly rely upon to model, predict, and communicate the climate emergency are themselves resource-intensive. The International Energy Agency projects that the global data center electricity demand will roughly double between 2024 and 2030, with AI-related demand tripling over the same period, carrying a parallel and largely undisclosed water footprint for cooling. These are not contradictions to be resolved rhetorically. They are the material context in which any human rights approach to the climate emergency must operate, here and now. Joy, connectivity, and even tools of knowledge production carry an environmental cost, and a right-based approach must be honest about what that costs rather than exempt itself from it. It is against that background that I turn to our advisory opinion, OC 32, on climate emergency and human rights, requested by Chile and Argentina and Colombia, and deliberated over 4 sessions, adopted on May 29, 2025, and notified on July 3rd of that same year, and specifically to its treatment of differentiated impact. The opinion analysis can be read for the present purposes as organized around 3 pillars: substantive rights, procedural rights, and differentiated impacts on groups in situations of vulnerability. I want to flag briefly that vulnerability is not a neutral descriptive term. It is a contested category in political philosophy. Martha Feynman's vulnerability thesis is instructive here, in my view. Vulnerability is not the special condition of discrete, pre-identified groups, but a universal and constant feature of the human condition that the lost fiction of the autonomous, self-sufficient subject obscures. Read this way, naming children or indigenous peoples as vulnerable is not a claim about their deficiency relative to an unmarked norm. It is a claim that the state has failed to build resilience around structural the exposed populations, while the same exposure, unaddressed, awaits everyone else. Used carelessly, this label still risks casting children or indigenous peoples as passive recipients of protection rather than its agents. The court's own reasoning resists that reading. Children's best interests are paired, in the opinion, with the right to be heard. Indigenous peoples are recognized not only as affected communities, but as holders of knowledge relevant to the environmental protection. Vulnerability, properly used, describes exposure to structural risk, not diminished agency. About children, the court's judgment in the case of Habitantes de la Roya versus Peru, delivered in November 2023, is instructive even though it did not concern climate change directly. The court found Peru internationally responsible for decades of harm caused by metallurgical pollution, given particular weight to heightened physiological susceptibility of children. That judgment already linked the precautionary principle to the state's duty to preserve the environment so as to afford future generations opportunities for development and the conditions of human life. What the court called the principle of intergenerational equity, a doctrinal thread that OC 32 develops explicitly and substantially further. On indigenous peoples, the territorial and cultural dimension of environmental harm, loss of land, water scarcity, disruption of the intergenerational transmission of traditional knowledge, requires that adaptation and mitigation measures be designed through free, prior, and informed consultation, not imposed as technocratic solutions. The climate context raises the stakes. Mitigation measures themselves, including large-scale renewable energy infrastructure, can encroach on indigenous territory in ways that require the same participatory guarantees traditionally demanded for extractive projects. On future generations, the opinion's genuine contribution lies in its treatment of intergenerational equity. The court had already anchored this principle in Habitantes de la Roya versus Peru. What OC 32 does, and does valuably, is develop this thread substantially further, detailing the state's obligations of prevention and due diligence toward present and future generations. This is a question the European Court has already begun to resolve, and Judge Anya Sieber has told us about that in Veren Klima Signorini versus Switzerland, where the Grand Chamber found a violation of Article 8 of the European Convention arising from Switzerland's failure to adopt an adequate regulatory framework on greenhouse gas emissions, and the African Court on Human and People's Rights still confronting in a request for an advisory opinion. I think comparative dialogue among our three systems on how to operationalize intergenerational obligations would sharpen definitely all our jurisprudence. Vulnerability, and with these final remarks, I'm closing my brief intervention. Vulnerability in the inter-American system is not a peripheral concern. It's precisely the lens through which the individual, collective, present, and intergenerational dimensions of the climate emergency become legally intelligible and enforceable. Thank you.
Thank you. I'll turn directly to Judge Duncan Gaswaga of the African Court of Human and People's Rights. And we look forward to your brief initial remarks, and I'm hoping we will then have time for questions.
Thank you, Chair. Good morning, everyone. I'm happy to be joining with you this morning, and I bring you warm greetings from the African Court. I also want to thank my sisters who have already spoken for laying the stage. My discussion will bring to light the relationship between human rights and the climate change, and the question how respect for human rights can respond to the global threat of climate change, and how international human rights courts and tribunals are rising to the challenge of this historic moment. There is no way I can demonstrate this other than by using the African Court's emerging environmental jurisprudence, which rests on two landmark decisions. And these decisions taken together illuminate both the promise and the specificity of African systems contribution. And these are the cases of Kenya, of the Ogiek people, and the Cote d'Ivoire case. But before I do that, I want to make a comment about one of the decisions that was made by the African Commission on Human and People's Rights. That is the Sarah case versus Nigeria, where there was the exploration by Shell and the NNPC in Ogonland caused pollution, health damage, and loss of livelihood, and so on, thereby violating a number of rights, the right to life, health, property, natural resources, and so on. The significance established by that decision is that the right to a satisfactory environment under Article 24, and this was the first time Article 24 of the Charter was being interpreted. The Commission recognized state responsibility for regulating corporate environmental harm and developed the doctrine that states have obligations to respect, to protect, promote, and fulfill human rights. So this is the foundation case for all environmental litigation in Africa and has also influenced environmental jurisprudence globally. I now want to turn to the two cases I talked about earlier on and discuss the Ogiek case, and then later on, we'll go to the other one in the second phase. The Ogiek are an indigenous hunter-gatherer community whose survival has been inseparable from the Mau forest complex in Kenya for generations, beginning from the colonial times all through to the independence. The Kenyan government repeatedly evicted the Ogiek from their ancestral forests, ostensibly to protect it as a public resource, So in 2017, the court found that Kenya had violated 7 provisions of the African Charter, including the rights to property, religion, culture, natural resources, and so on. But what is the significance of this case? That's what I'm looking for. The significance of this judgment for the climate and rights nexus lies in the court's recognition of the unique relationship between the Ogiek and the Mau forest. The court, rather than viewing the Ogiek's presence as incompatible with the conservation objectives, the court acknowledged their deep historical, cultural, spiritual connection to the forest and affirmed their right to continue living and using their ancestral lands. Now, this recognition is particularly important in light of contemporary climate science, which increasingly highlights the role of indigenous peoples in maintaining and protecting critical ecosystems. So, although the court did not explicitly frame its reasoning in terms of climate change, the judgment carries significant environmental implications. By safeguarding the Ogiek's rights and their traditional stewardship of the Mau forest, the court indirectly contributed to the preservation of an ecosystem of exceptional ecological value. The Mau forest is not only central to the Ogiek's identity and way of life, it also serves as a major carbon sink, an essential watershed, and a reservoir of biodiversity. In this sense, the judgment illustrates how the protection of indigenous people's rights can simultaneously, at the same time concurrently, advance broader environmental and climate objectives, reinforcing the growing interdependence between human rights protection and climate governance. So the Ogiek case establishes a critical precedent, the leading judgment on indigenous people's rights. The displacement of indigenous people from their ancestral territories in the name of conservation of development is not only human rights violation, it may itself be a form of environmental harm. So future climate litigation may draw on this logic to argue that states which displace forest communities, clear land for large-scale agriculture, and deny indigenous people control over natural resources are both violating rights and undermining the ecological systems on which climate stability depends. At this historical moment, as can be seen, the African court is operating at a unique intersection of normative development and practical agency. This is not a climate change case in the strict sense, per se, as you can see, but the court had to think outside the box. The jurisprudential infrastructure is now being laid, and that's the promise I talked about initially. An enforceable right to a satisfactory environment, positive state obligations to protect populations from environmental harm, and the recognition of indigenous peoples as guardians of ecosystems. So the African court's contribution to this architecture matters for reasons even beyond doctrine. So that the court is developing the tools to hold the states accountable for the conditions that sustain human life is not merely a legal development. It is, in my view, at this historical moment, a question of justice. The biggest challenge, as I conclude, however, is at this pivotal moment, is the lack of a legal regime, prescribed procedures through which purely climate or environmental matters could be lodged and litigated before the international human rights courts, since international environmental law does not provide for specific environmental law courts. And finally, I should say that all is not lost. The African court continues to be innovative and strategic by employing the rights-based approach in climate change adjudication. And the two precedents which I am discussing today present a golden opportunity for the development of a new and accommodative international legal order. Thank you very much. I will then discuss the other later.
Warmest of thanks, Judge Gaswaga, Duncan. It is marvelous to hear your views at such a unique moment in history and to know that your court is holding in its hands and valuing this important opportunity. Warmest of thanks indeed to our three distinguished judges for these truly extraordinary remarks and for your courage, your commitment, and your collaborative approach in coming together today to discuss these existential issues. I know that advocates Muskan and Yushi have been especially monitoring our online forum for questions. Muskan and Yushi, would you be able to share some comments? And I think there will indeed, because of the discipline that has been shown by all three of our speakers, be time for a round of replies. Some questions from our online audience.
Thank you, Professor. I will start. I collect some really excellent questions from our audience. And Muhammad Sheikh from Pakistan, Dr. Abdul Lamin Kamara from Senegal, and Tavashashi Sheikh from Kashmir have especially noted the importance of ensuring that international and regional human rights judgments produce meaningful change in practice. They would welcome the judge's perspective on how court can strengthen strict compliance with climate-related human rights obligations, and while respecting the limits of judicial authority and addressing the unequal enforcement of international law between more powerful and less powerful states. This is the first question about compliance, enforcement, and judicial legitimacy. And the second question is about developing countries and overlapping vulnerability. Alido Aduku from Nigeria, Bella from Philippines, Dimashi from Mauritius, and Mahmoud Baha from Afghanistan have highlighted the particular challenges facing developing countries, small island, developing states, and community experiencing multiple and overlapping vulnerabilities. They have asked how international and regional courts can support climate resilience, disaster response, and sustainable development where domestic institutions and the resources may be limited. And Muskan, over to you.
Thank you, Yushi. We have two more questions that we've have from people all around the world. The first question is from Lydia Subra Ghosh from India and Jivish from Mauritius. They have asked the importance of indigenous people, traditional knowledge, and vulnerable communities in responding to the climate emergency. They would appreciate and welcome the judge's perspective on how human rights law can be better used to protect indigenous land and cultural rights, recognize traditional knowledge, and address questions of climate repartitions and historical injustice. And the last question for the panel, which relates to public awareness, youth engagement, and access to justice. We have one more question, and only if time permits, from Ataman from Turkey, Kevin from Kenya, and an anonymous participant who were concerned about the awareness of the SDGs in developing countries and have asked how courts and human rights institutions can make climate law, judicial decisions, and sustainable development more accessible to young people, local communities, and the wider public so that the people can better understand and exercise these rights.
Thank you so much to Advocate Yushi and Advocate Muskan for excellent and very fast analytical work in order to be able to bring together the common threads of the questions. I'm going to turn back now to our panel of judges and invite them to choose any of these questions that they are most comfortable answering, starting, of course, with Judge Anya, and then Judge Patricia, and then Judge Duncan. And I would also like to ask if any of our opening speakers or if the judges would like to respond to the questions as they appear in the Q&A. It's absolutely fine and indeed deeply appreciated by our audience from around the world if you could do so. Judge Anya.
Thank you very much, Professor. I tried to follow the very interesting comments and questions while listening to my co-speakers, and I find them fascinating. So perhaps we have some speakers who would be even better to do some of the presentations, and they are introducing new aspects that we haven't touched on. I would like to focus on two questions that have been asked. The first was about the enforcement and then subsequently about the legitimacy. Well, with regard to enforcement, I think our court is somewhat relieved from really engaging with enforcement, which is very difficult for international courts in the first place, because the Council of Europe has the Committee of Ministers whose task is to oversee the implementation. So it's part of a political process, and that relieves us from repeating what we've been saying again and again, and then leaving it more to political pressure within Europe that may have varying results, but I think it's better placed in the Committee of Ministers' hands so that we can really focus on our judicial functions. But as you may recall, in the second part of my presentation, I also alluded to the essential role by domestic courts. It's not only our international court for Europe, but we are trying to motivate two things: the domestic courts and, at the same point of time, the legislator, in order to do something on the ground. Because I mean, in Strasbourg, we are still fairly far removed from the problems, and I think they can be much more context specific. If you allow me a last remark with regard to the legitimacy, I think this is a very valid question, and which has also concerned us a lot. I think in the end, we also need to be, as judges, we need to be aware of our limits. We are not scientists. We are not better placed than democratically legitimized parliaments to decide which choices to make. And therefore, we have a sort of an oversight function, but we cannot substitute ourselves to the domestic legislator. Therefore, I think, finally, I think you have to consider our jurisprudence in this more global context where we are trying to activate different partners, and where we are only playing a complementary role to the Paris Agreement. Thank you.
Absolutely. Thank you so much. I'm going to turn to Judge Patricia as well. I'm guessing which ones you will wish to answer, but please.
Well, just to say that I completely agree with which Anna has said, in order that it's very relevant to understand or to read the opinion in the light that it calls it calls the governments and states to actually act and to understand. I would say that one of our main discussions and what would try to really transmit in our opinion is that the Paris Agreement is a treaty. I mean, it's simple to say it, but sometimes you can feel it's difficult for states to really understand or really embrace it as what it is, a set of obligations that they are that had to be really complied, you know. And the other thing is that, of course, it's important to highlight the role of domestic courts, because they are in the States and they are really dealing with the matters that are important to people in their everyday life. The opinion was intended, in our case, was intended to explain, like in full detail, which were their obligations and what was the content of the obligation. So it was a kind of a really pedagogical exercise as well, in order to clarify the states and to help states to comply their obligations. And regarding the, all the questions were very interesting, but I would like to spend just a couple of seconds addressing the question about indigenous knowledge. That's one of the things that we really highlighted in our opinion, that the importance of the traditional knowledge and the importance of really understanding and valuing that knowledge in the climate emergency, and valuing that knowledge in order to improve the different measures that can be adopted regarding the climate emergency. So as I said, our opinion is very long, but it has one I think one of the really interesting aspects of our opinion is that it really underscores the importance of scientific knowledge and scientific evidence, but at the same time says that the traditional knowledge has something to say and is something to contribute in order to improve the climate emergency. Thank you.
Yes, absolutely. Thank you. And I'm going to turn to Judge Gaswaga for a 3-minute answer before we conclude, and they automatically cut off our Zoom link.
Thank you very much. Very briefly, I would want to answer something to do with the accessibility to our judgments, especially when you talk about the young people. I think generally it's a big challenge for our judgments to be accessed, unfortunately, even by some legal professionals. But for the African court, we've tried in various ways to see how the court's work can be known out there. And we have come up with the partnerships with some institutions, universities, and so on, and also participation in some of these conferences. And we do a lot of work with the universities, with the young people, the youth, because somebody, and I really appreciate the questions. The person who asked the question especially was interested in the young people. How do they know about our work? And of course, the internet is also doing some good job for us. But that comes especially with the people who are self-driven and interested in the area of human rights. So there's still a lot of challenge. The court also does a lot of judicial diplomacy, and this helps us to extend the word across. But in all, I will tell you that we are still facing that as a challenge. And since there are so many brains around, many listening, we would welcome many ideas from them so that we can build this area together. Thank you.
Warmest of thanks. And we will also, I see 87 questions in the chat and at least another 20 that are being replied to by our colleagues, the judges. The incredible multitasking that they are showing is truly remarkable. This is a skill that no one tells the young people when they look toward law school, but it's deeply appreciated. Judges, I will thank you and turn to my co-chair, Professor Nandini, to help close.
I'd just like to, on our behalf, on behalf of hundreds of participants, I extend our gratitude to our 3 judges from regional courts of human rights. You have brought to us concrete insights and transversal issues, which we will continue to deliberate and discuss through the day. So thank you very much. And this formally concludes our Global Experts Plenary on Climate Change and Human Rights. Oh, sorry. This concludes the high-level Judges Plenary, and we will move on to the Experts Plenary on Climate Change and Human Rights. So thanks very much from all of us, from Montreal and from all around the world.
Thank you. We will turn to Dr. Tejas Rao to tell us how to join the next plenary.
Thank you very much, Professor Cordonier, Segger, and Professor Ramanujan, as well as all judges. And thank you to all of our participants. To all participants, please exit this Zoom link and please join us by clicking on the Zoom link in the program for the next Global Experts Plenary 1. This would have been also sent to you by email just now through Eventbrite. We look forward to seeing you throughout the day, and thank you very much once again for joining us.